Hi, this is Brian Weekley of Snow, Carpio and Weekley. I'm one of the partners here. I'm a certified specialist with over 30 years of experience in Arizona workers' compensation law. I'm going to talk briefly about the controversial subject of independent medical evaluations, or IMEs. IMEs are where an insurance company or third-party administrator chooses a doctor and sets the date and time of an examination for the injured worker to be examined by the doctor. The purpose of these independent medical evaluations is so that the insurance carrier can get answers to certain questions. And the common questions are, what is the nature of the injury? Is the injury related to the industrial injury, the reported injury itself? What is the diagnosis? What is the plan of treatment that's recommended? What is the injured worker's work status? Is the injured worker medically stationary or as good as they're going to get? Does the injured worker have permanent impairment, permanent work restrictions, and the need for supportive care? So these are the usual questions that an independent medical examiner is asked to answer in his or her purpose letter. They get a purpose letter from the insurance company. For folks watching from out of Phoenix, most independent medical evaluations are held in Phoenix, and the insurance company has to pay the travel to get the injured worker down to the medical exam in Phoenix. The exam itself is attended by the injured worker. The worker is alone in the room or with a chaperone, a doctor chaperone, while the examination takes place. The examination consists of some questions and then a physical examination, and then you're discharged from the room. And then a couple of weeks later, the carrier gets a report from the independent medical examiner and takes action based on that report. So a lot of clients ask me how an independent medical examiner's opinion, which may have taken place over a very brief time with a very cursory examination or brief examination, how that opinion can take precedence over their own doctor's opinions. And the answer is, it doesn't necessarily take precedence. But the insurance company can take legal action based upon the independent medical examiner's opinion. If the injured worker disagrees, then the remedy is to file a motion. It's called a 1061J motion, or protest a notice that's issued based on the independent medical examiner's opinion, and request a hearing. And the judge would listen to the injured worker, known as the claimant or the applicant, and then take testimony, usually by telephone, from the treating doctor, in other words, the injured worker's own doctor, and the independent medical examiner, and decide which of those opinions is more probably correct. So if there's a conflict in opinion, the judge resolves that conflict. So the independent medical evaluator's opinion is not dispositive. It's an opinion that the insurance company relies on. One more note on independent medical exams. I think that the word independent is a misnomer. It implies that there's no bias whatsoever in that opinion. I don't think that's true, and I think it's evident that there is some inherent bias when an insurance company intentionally chooses a specific physician to perform an examination and render an opinion. They're hoping for an opinion that is friendly to their side or their cause. So independent is a loaded term. I don't think it's representative of the actual process. It's important to note in any medical examination, in any workers' comp case, there are certain key terms we're looking for. Those are terms that affect an injured worker's ability to get benefits. I do suggest you talk to somebody that knows what they're doing in the arena of workers' compensation to review any independent medical evaluation reports and anything else and decipher what it means for you legally. Thanks so much, and we look forward to hearing from you.